Morning, everyone. Welcome to today's Dental Negligence Case Law update, an area on the move. Thank you for joining us this morning for this morning's webinar. We are going to get started because we're on a relatively tight timescale today of 45 minutes. You will, if you're familiar with Teams by now, you will be familiar with the Q&A function, which can be found at the top of your menu screen. If you want to enter any questions as we go through into that screen, that's the best screen to do that. Try to avoid entering any questions into the chat. We may miss them otherwise. Anything we can't answer, we'll obviously endeavour to get back to you after today as well. So without further ado, we are going to get started. So just moving forward. So just a quick introduction to presenters today. So this is myself, I'm Dan Jacklin. I cover personal injury, clinical negligence and regulatory work, and certainly in this context, cases with health and safety and inquests as well. And I'm joined today by Wright, who I'll let introduce himself as well.
Yes, hello everyone. I shan't bore you with my background. There's a brief history of me on the slide there. My practice covers costs, personal injury, clinical negligence, and employment as well, although not so relevant today.
All right, so we're going to have a look at two key areas today. We're themed all around dental negligence cases, so that's our theme for today's webinar. We're going to start with a section on failure to advise cases, and I'm going to talk through that. And then Connor is going to take the other dental negligence decisions, which includes sort of a range of different issues, some costs issues, and a couple of other bits that have come up in the dental negligence sphere over sort of recent years. And then, as we say, we'll end with answering any questions as well. So without further ado, let's get into the first section. So failure to advise cases. In terms of where we're going to start, just a reminder of some of the key principles. So you'll be aware, if you've been doing clinical negligence cases for a while, there are a couple of Montgomery cases, and certainly the Lancashire Health Board case in 2015 sets out one of the key principles of any failure to advise case. A doctor is under a duty to take reasonable care to ensure that the patient is made aware of any material risks involved in the treatment and any reasonable alternative for variant treatments. And we'll come back to the second Montgomery case in a moment to talk a little bit more about alternative treatments. Derby and National Trust also set out another key principle around these cases. Only the liabilities that flow from the thing the doctor failed to warn the patient about, which subsequently materialised, are recoverable. So if there are, for example, risks that the doctor has failed to advise on, but actually they don't go on to materialise or they don't go on to contribute to the harm that's caused, then there will be a break in the chain of causation. Any losses which arise from a failure to warn of other unrelated issues are not recoverable. So that's the first two principles of the failure to advise cases. I should say as well at the outset that if anyone wants a copy of the slides, we're more than happy to share those afterwards. We'll provide you with some contact details from our marketing team, and they'll be able to send you the slides, just save you making quite so many notes as we go through. And just another few key principles. Hodson and East Berkshire Area Health Authority, again quite an old case now, and Greg and Scott. The claimant cannot recover damages apportioned according to the chance the harm may have been avoided. And Chester and Ashbar and Korea and North Staffordshire NHS Trust, if the claimant was not properly warned of the risks and that risk subsequently materialises, then even if the claimant would have undergone the same treatment at some later point, there is no defence to that claim. And the right to make an informed choice justifies the application of the special rule. So between those four principles, those are sort of the bedrock, if you like, for failure to advise cases. They underpin the key principles that have to be applied in these types of cases. What we're going to do now is have a look at some more recent dental negligence cases in this area that kind of highlight the principles associated and put these principles into practice, so to speak. So, dealing with the second Montgomery case, which is only 2023, so a relatively short time ago. This case dealt with the professional practice test, as it's been termed. The claimant cannot recover damages apportioned according to the chance of harm that they may have been avoided. The professional practice test is essentially the doctor who's taken a view that a treatment is not a reasonable alternative for a particular patient will not be negligent in failing to inform the patient of that alternative treatment if the doctor's view is supported by a reasonable body of medical opinion.
Just before you move on, Dan, you were telling me, weren't you, the other day about an extraction case that you were dealing with. Perhaps you can share some views on your experience of applying the test on the ground.
Yeah, so extraction cases are quite common ground for failure to advise issues. This is because you've got a choice as a dentist to either remove the tooth or try to do some kind of restorative or repair work on the tooth itself. Clearly, if you fail to advise on the specific risks of repairing the tooth versus taking the tooth out, then this is where this type of case tends to arise. And from that, a case that I dealt with recently was around an extraction of an L2 tooth. And essentially in that case, there was a failure to advise about the risk of damaging the bone in the gum, which was then cracked when the extraction took place. And so that case was based around essentially failing to advise around the risks of something like that happening. In that case, the claimant suggested that they would have adopted for the repair work as opposed to the extraction had they been aware of that risk.
Certainly, I had a recent case that ran along similar lines, and again based, among other things, on failure to advise. That was a case just thought arising from that, based on a series of cantilever bridges that were fitted to as a prosthesis to the claimant's remaining natural teeth. There's a failure to advise, the claimant said, on the conduct of restorative treatment to some of her teeth that ended up being removed. There were a series of root canal surgeries, which again contained both negligent treatment and failure to advise. Those root canal treatments were then poorly done, and the claimant lost the remainder of her natural teeth, so the lower teeth that she had left prior to treatment. So, a significant course of pain and suffering, indeed loss of amenity, difficulty eating, and so on. According to the expert, there was a high likelihood of failure of those cantilever bridges, and so I think that just shows us, some of the difficulties that can arise from failure to advise, the course of treatment that can ensue, and the suffering that follows. There were various options, including restorative treatment and implants, among others. It just raises a thought to me, and Dan, I don't know what your thoughts are on this. What if during that long course of treatment, the dentist had realised that there was a problem, that either restorative treatment or removal of the tooth rather than continued attempts to conduct root canals was the right way to go? If the dentist had realised earlier that they'd made a mistake, what impact do you think that would have had on the ultimate result in the case?
Yeah, so I think where we've got failure advice cases where there's a failure to advise initially, but then the dentist maybe realizes at a later stage that actually they've given the wrong advice, and they then take steps to try to rectify that by then carrying out the correct procedure. That type of case can be particularly tricky when we're talking about failure to advise cases, because obviously the word failure to advise is sort of time limited in that sense. It's only up to a certain point. And maybe the harm hasn't necessarily been all incurred by the time the dentist realises that that actually they've advised on the wrong treatment. So it might be the case that the damages are limited in that sense in those types of cases. But that's a case that increasingly I think I'm seeing, and I know that you've mentioned as well. In terms of Bailey then, so this is a 2025 case. Mrs. Bailey sought damages for negligent treatment by Dr. Bijlani in May 2018. The treatment was contracted with the practice. We have a situation here where Mrs. Bijlani breached her duty in several respects. She failed to carry out a full and proper assessment of the claimant's suitability for the proposed implant. She also failed to rely upon up-to-date radiological evidence, and I think we see that quite regularly. Dentists essentially trying to avoid charges for customers by avoiding doing the necessary radiological work before carrying out treatment. Failure to inform the claimant of the risk of performing the procedure. In this case, there was only 1 millimetre clearance between the teeth, whereas usually 1.5 millimetres, according to the expert evidence, was required as a minimum. Consequently, failed to obtain informed consent as a result of that, and also failed to stop the procedure if the patient was unable to remain still due to severe pain. In this case, the patient was experiencing significant pain during the procedure itself. And the dentist failed to recognise that pain threshold had been passed, and essentially the treatment should have been stopped even though it hadn't been completed at that point, in order to bring the pain under control before any further treatment continued. Now, what's particular about this case is that the card issuer was also a defendant, so that's MBNA was the card issuer. So under those proceedings, we have cases, so Section 49 of the Consumer Rights Act and Section 75 of the Consumer Credit Act 1974, essentially enabled a claim to be brought against the card issuer as well. So the judgment is not clear in my reading of it why there was a need to sue the card issuer as well as Mrs. Bijlani. It may have been because Mrs. Bijlani may not have had sufficient insurance cover in place, and so there was potentially going to be a shortfall in what was able to be recovered. That may have been one reason why you bring in the card issuer as well. But of course, in the general principle is you want to sue as few dependents as possible and recover, your full damages from that single defendant. But it is worth considering when to bring the card issuer in. That's something that certainly a lot of instructing solicitors I speak to maybe haven't considered at that point. This is clearly in the case of where somebody pays with a credit card for the treatment that's carried out. But an interesting case nonetheless, and well worth having a look at. And then in terms of Winterbotham and Dr. Sharak, this is a 2024 case. This is a case where the lingual nerve was damaged during an unwanted extraction. The patient was not told about alternative treatment. In this case, that was a coronectomy, which would have been a low risk alternative. Now, the schedule in this case stood at just under £1 million, which is a very significant sum for a dental negligence case. We see typically sums that are substantially less than that in these types of cases. And one of the reasons that the schedule, as I understand the judgment, was so high was because Mrs. Winterbotham had essentially a job which was a speech and language therapist. And as a result of her injury that she suffers when the lingual nerve is damaged, she then has difficulty performing her job and is limited in the number of days that she could work. And so there was a sizable loss of earnings claim associated with this case. Now, Dr. Sharak says, and is reported in the judgment, not to have regarded her case as a high-risk case, which the expert evidence said that he should have done. And he should have done that because the LR8 routes were in close proximity to the dental canal. So the expert evidence was quite clear. This should have been a high-risk case. There should have been adequate consideration and explanation of the risks associated with this type of procedure, in particular the risk to the lingual nerve. That wasn't done, and as a result of that, this case then comes about. Now, in terms of damages, the judge found for Mrs. Winterbotham that she would not have undergone the extraction on the balance of probabilities. The judge also found that but for the negligence, Mrs. Winterbotham would not have undergone the coronectomy. Would have undergone the coronectomy, I should say. Damages were assessed at 265,000, so substantially below the 1 million valuation, but still a substantial sum of damages we don't often see in a dental negligence case. The judge makes particular remarks in this case about why Mrs. Winterbotham's evidence was deemed to be so credible, particularly in respect to whether or not she would have undergone the coronectomy. And there's some quite useful comments in this judgment which explain the fact that relevant concessions were made by Mrs. Winterbotham when giving evidence. She accepted the limitations of her knowledge and her ability to hypothesize about what she would have done, in an alternative situation. And a number of other comments about the quality of the evidence of Mrs. Winterbotham that led to this finding that are quite useful to reflect on witnesses in your cases and thinking about whether they share some of these characteristics as well, because those sorts of factors are what judges take into account that they then find are particularly persuasive. So that's my section of a couple of judgments. We're now going to move into an assortment of cases from the courts around dental negligence. So we're going to deal with cost issues and a couple of other issues as well. And I think Connor is going to start with Hughes and Rattan.
Indeed, thanks for that, Dan. It's always interesting to hear when the courts are robustly analysing some of these perhaps more fundamental principles, in this case, of failure to advise. I'm sure everyone here will be interested to hear as well about the benefits of strong witness evidence, and it's something that certainly I can't stress enough. Perhaps a matter for an early conference, a good proof of a witness to suss out just how good their evidence is going to be in due course. As Dan says, I'm going to talk to you now about a series of cases. The first few perhaps could be categorised as finding the right defendant, and the final one that I'm going to talk about is perhaps closer to cost. I'm sure you'll all suffer me on that. As for Hughes and Rattan, which is on the slide there, this case arose out of the claimant, Iris Hughes, who received dental treatment on a number of occasions from August 2009. That was at Manor Park Dental Practice in Kent. Dr. Rattan was the owner and the sole resident dentist at the practice. I'm going to go through a number of factors here, facts that are relevant to the decision that we're going to talk about. He arranged for a number of dentists to cover the work that he couldn't do. The claimant had been seen by 6 dentists during the material period and alleged that 4 of them had been negligent. One of them was Dr. Khan. Dr. Khan was a trainee that was employed by Dr. Rattan. So there was no dispute as to Dr. Khan that Dr. Rattan was vicariously liable for his negligence. The other 3 dentists against whom Mrs. Hughes complained were associate dentists, and they were brought in on contracts for services. Relevant to that, Each dentist had appropriate professional indemnity cover. They paid their own tax and didn't receive any sick pay. They also all worked for other practices. Appointments were made, though, via reception staff at the practice. NHS work was provided. It was done under the General Dental Services contract between the Primary Care Trust and the defendant, Dr. Razam. And indeed, Schedule 1 to that contract named the defendant as a contractor. The associate dentists were on British Dental Association standard terms, and there are indemnity clauses as well. The claim was issued in the county court. It was relatively low value at about £20,000. District Judge Fine ordered the trial of the preliminary issues which related to the identity of the defendants. There are two issues: a non-delegable duty of care and, in turn, vicarious liability. That concerned only the three associate dentists for the reasons that I've already given. The matter was transferred to the High Court and was heard in June 2021 and eventually was appealed to the Court of Appeal. Dan, if you could just move the slide over to the next one. So the first of the two issues that I'm going to talk about is the non-delegable duty. Lord Justice Bean relied on the classic case of Woodland and Swimming Teachers Association and others, which is a 2014 Supreme Court decision. There are a number of factors set out there in terms of why Lord Justice Bean found that there was a non-delegable duty. And they include, as set out at number 1, that a dental patient is obviously vulnerable when receiving dental care, and there was an antecedent relationship between the claimant and defendant, which entailed a positive duty to protect the patient from harm. There are some of the finer points there as to the relationship between the contractors so the associates and the practice. And these are all things that are relevant to take into account among the things that I've already mentioned in terms of both non-delegable duties of care and indeed vicarious liability as well. But importantly, as I say, Lord Justice Bean found that there was a non-delegable duty of care, which will obviously come as welcome news for claimants. And so that's that issue. As for vicarious liability, which takes us on to the next slide.
And I think just whilst that slide's changing, the judge in that case is approaching it almost as two columns of a table. So what are the factors that are influencing the decision in terms of for the decision, and what are the factors that are against? And I think that's a very useful way of thinking about these issues. You want to list the factors that are for and the factors that are against, because that's exactly what the judge will be doing in the judgment as well.
Well, yes, precisely, and that's exactly what we see here in terms of vicarious liability as well. This issue was determined. Lord Justice Bean decided on the basis of the test that was set out in various claimants and Barclays Bank, again a Supreme Court decision from 2020. It's not dissimilar in a way to the cases that I often rely on as part of my employment practice, including but not limited to trustees of the Barry Congregation of Jehovah's Witnesses and BXB. The test is essentially twofold. And that is that there has to be a relationship that's akin to employment, so not necessarily strictly employment, but akin to it, and that the wrongful conduct was so closely connected with what was authorised in that relationship that it could be said to have carried out by them in the course of that relationship or the employment, as the case may be. There are a number of factors again that have been set out by Lord Justice Bean as to whether or not there should be vicarious liability in this case. This is a case where the associates were free to work for as many hours or as few hours as they pleased. They paid their own tax and insurance, as I've mentioned, and indeed they paid for their own clothing and equipment, and there was no disciplinary or grievance procedures. In this case, and in my view, it's a relatively clear case considering the authorities from the other side of my practice. There was no vicarious liability in this case. And so that's important because it means that in order to bring claims against, for the acts of the associates, claims would have had to be brought against them as defendants. Raises certainly some questions about those sorts of contractual issues. It does raise one issue that springs to mind with respect to how we might find out, how a claimant might find out the relationships between the various dentists that might have treated them and the practice that they worked for. I think that's a question of pre-action disclosure. There are a number of options, including subject access requests and indeed applications for pre-action disclosure or for early disclosure. Those applications can be quite complicated in these cases, in my experience, and it's something to consider. Do get in touch with us if there's anything that we can help with in that regard, because there can be some thorny issues about who those applications are brought against. Just reflecting on Hughes and Rattan, probably safest to assume in the first instance that claims should be brought against all of the potential parties as separate defendants, unless there's evidence to suggest that they don't need to be defendants in the case. Obviously, there are costs implications in terms of bringing claims against a whole number of defendants, and certainly, Dan, I know you will have experiences of that as well. Poorly, then, is a claim that goes hand in hand with Hughes and Rattan. This again was a dental negligence claim and is part of this wider skirmish, if you like. The claimant was a patient between 2012 and 2018. She was treated by 4 different dentists that she alleged had been negligent. She issued proceedings against the defendant in this case, but not against the individual dentists. She alleged that the defendants owed her a non-delegable duty of care, which we've already discussed, and that they were vicariously liable. She didn't request permission to join the other dentists as defendants. Instead, the defendants applied to add the other dentists under CPR Part 19, which is the court's power to add additional parties. It's a strange situation, quite an interesting question, because it's not the case that the defendant was bringing a Part 20 claim against the other defendants. They were just applying to add them as parties. The court considered its powers under CPR 19, which say that the court may order a person to be added as a new party if it's desirable to add the new party so that the court can resolve all the matters in disputes and proceedings, or that there is an issue involving the new party and an existing party which is connected, and that it's desirable to add the new party so that the court can resolve that issue. The court also, of course, as it should have done, considered the overriding objective, which encourages claimants to bring to streamline proceedings where they can, and indeed for the reasons that we've discussed, limiting the number and the complexity of issues that the court has to deal with, saving expense and indeed time taken for the litigation. The court endorsed the dictum in Milton Keynes Council and Viridor, where it was said, it was a cost case, where it was said that it would be a nonsense if a defendant could join another defendant into the proceedings against the claimant's wishes. in circumstances in which the claimant would then be potentially liable for the costs of the new defendant. And I think that serves to show the appeal, of course, was allowed, and the claim is due to proceed, was due to proceed against the practice alone. Largely, that of course would have turned on similar issues to the Hughes and Rattan case that we've just discussed. I think this case serves to show that we have to be quite careful as to the procedural steps that we take in terms of how these cases are litigated. The obvious answer, as the court noted in the Pauli decision, was that further claims could be brought by the defendant against the additional dentists under Part 20, and certainly that, in my view, would have been the orthodox position. A number of applications were stayed pending this appeal, and indeed it's likely, I suspect, that those applications would have been decided similarly. An interesting case about NHS contracts that many of those in attendance today, many of you in attendance today may not realise, is Kira. And Kira was a case about a claim that was brought based on, as I say, an NHS contract. The contract in question was subject to Section 9, subsection 5 of the National Health Service Act 2006, which states materially that a contract must not be regarded for any purpose as giving rise to contractual rights and liabilities, and that the appropriate body through which to bring a complaint under that contract would be the NHS Resolution and Primary Care Appeals Service, PCAS. So the Court of Appeal was considering this question in Kira, and indeed has upheld the earlier decision of Patalia. The long name of that case is Patalia and National Health Service Commissioning Board, which is a 2014, again, Court of Appeal case. The only way in which an NHS contract can give rise to any contractual liability is if a written variation is agreed by both parties. And so that was the issue before the court, whether it fell within the court's jurisdiction to resolve at all. And given what I've already discussed, the court unsurprisingly held that 1, it was an NHS contract, 2, it hadn't been varied, 3, the court was of course bound by Patalia, as I've already discussed, and 4, accordingly, the court was right to strike out the claim form. And so the appeal was dismissed. And so that's just a useful point to bear in mind in terms of contractual claims based on NHS contracts.
I think we've covered some of this slide as well, haven't we? I think in that summary.
We have indeed, yes. So this is just setting out some of the decisions on which the court relied, and we've got Vas Antifellas and NHS Commissioning Board there, where essentially the same principle was stated.
Okay.
The final case that I want to consider today is a costs one, as I've already warned you, perhaps. That is Robinson and Liverpool University Hospitals NHS Trust and Mercia. Mr. Mercia, importantly, was the medico-legal expert that was instructed by Miss Robinson. On the first day of trial, there was a discussion between the judge and Miss Robinson's counsel. That was an attempt to define the central issue in the case, and the issue was eventually articulated as whether or not a reasonable body of dental surgeons would have concluded during the course of surgery that the tooth was restorable based on the information that the dentist had available. Now, framed in that way, Mr. Mercia said that it was not a matter that he previously expressed a view on. He conceded during evidence that it wasn't unreasonable for the dentist to leave the tooth in situ, And he also acknowledged further that decisions about surgery weren't within his expertise. Certainly a bad day for Miss Robinson in that regard. Following that evidence, perhaps unsurprisingly, counsel for Miss Robinson withdrew her claim. At that point, the respondent's medico-legal expert hadn't given any evidence. The recorder wasn't told why the claim had been withdrawn, and she didn't give any judgment on the merits. Ms. Robinson asked the recorder for 21 days to make an application for a third-party costs order against Mr. Mercier, the expert. Mr. Mercier was naturally joined as a party to determine that application. And indeed, a third-party costs order was awarded in the sum of £50,543.85 against Mr. Mercier. And so the appeal ensued. Mr. Justice Sweeting found that Mr. Mercier's performance wasn't an exceptional case. It didn't involve a flagrant or reckless disregard of an expert's duty to the court. And so on the facts of this case, it wouldn't be just to make a cost order against him in any amount. So the appeal was allowed. Just considering some of those issues, because it's quite a common issue that comes up in these sorts of proceedings, CPR 46.2 deals with non-party cost order or third-party cost orders. And it refers to an exercise of the court's discretion. The authoritative decision, it could be said, was a Privy Council one called Dimmock's Franchise Systems and Todd, which is a 2004 case, of course not binding. And in that case, it was said that non-party cost orders will only be made in exceptional cases. Exceptional simply means, it was said there, no more than outside the ordinary run of cases, where parties pursue or defend claims for their own benefit and at their own expense. The Court of Appeal considered the issue further in a case called Deutsche Bank and Sebastian Holdings, which is a 2016 case. And it was said there that the only immutable principle that was applicable to the court when deciding whether or not to make a non-party cost order is that the court's discretion must be exercised justly, perhaps unhelpfully. It's generally regarded, though, and it's important for, I think, everyone listening today, that that is a very high standard. So it's not something to be taken lightly at all. An illustrative case in point was County Court in Manchester decision of the Mayor and Lancashire NHS Foundation Trust. The relevant facts were relatively straightforward. It was a clinical negligence claim against the NHS Trust. It related to breach of duty, and the claim relied on the expert evidence of Mr. Jamil, a consultant spinal surgeon. Perhaps oddly, in cross-examination at trial, Mr. Jamil was said to be wholly unable to articulate the test to be applied in determining breach of duty in a clinical negligence case. He accepted that he didn't know what the test was, and of course, given this collapse by one of her key witnesses, the claimant discontinued her claim. By the time of the third-party costs hearing, Mr. Jamil accepted with hindsight that he wasn't fit at the time of trial to give expert evidence. He said that was due to his mental health problems. He maintained, though, that he didn't appreciate that at the time. He further maintained that he was in fact aware of the Boll and Belido test, but that cross-examination had triggered an adverse psychiatric reaction since opposing counsel had reminded him of an interrogator who had interrogated him in Iraq. Mr. Jamil had taken sick leave from his clinical practice before retiring in 2018. but he'd not told the claimant's legal advisors of his sick leave. The judge's analysis was relatively succinct. It was the judge accepted that a jurisdiction to make a third-party costs order mirrored the jurisdiction to make a wasted costs order, although a slightly different provision under the CPR. And that the judge in that case was satisfied that Mr. Jamil had engaged in improper, unreasonable or negligent conduct. Applying the test that we've already discussed, the judge found that at the time of the cross-examination, Mr. Jamil didn't know what the relevant test was. The judge didn't accept his explanations as to the reminder of counsel's cross-examination of someone who had interrogated him, and indeed found that Mr. Jamil should have taken sick leave from his medico-legal practice at the time he took sick leave from his medical practice in November 2017. On the balance of probabilities then, Mr. Jamil had caused the defendant to incur all of the costs that it had incurred after November 2017. It was said that he'd failed comprehensively in his duties to the court from that time in a manner that was improper, unreasonable or negligent. And as such, the costs order was made against Mr. Jamil in the sum of £88,801.68. That, of course, is a very unusual case, one in which the expert evidence fell far below the standard that we would have expected. I think that's just a demonstration of how high the bar is in terms of third-party costs orders, but something to bear in mind nonetheless, especially where Quox applies.
And I think a reminder to check your expert witness's insurance cover, because in a particularly sizable claim, we don't ordinarily consider, certainly from a barrister's perspective, the insurance cover of the expert witness. But certainly in a large claim, that might be something that does need to be checked as part of normal procedure.
Certainly.
All right, so that covers what we had intended to cover today. So I hope some of that was useful. The presentation was entitled An Area on the Move, and there are a number of areas there that we've covered where essentially there is progress being made on the underlying case law, not just in dental negligence, but broader than that. And we've seen that most recently with the third-party costs orders at the end. Now, in terms of questions and answers, we can have a look. We've only got a few minutes to have a look at that. But if you have any questions, then please put them in the Q&A. Equally, if you'd like to send us an email afterwards, you're more than willing to do so. And if you'd like a copy of the slides, then again, what we'll do is we'll put in the chat now just our contact details and as well Chambers details to get a copy of the slides. But other than that, have a good day, and we wish you well for the rest of the week.
Indeed. Thanks very much for attending.